Hello, welcome to SERMAPod. This is the Sports and Entertainment Risk Management Alliance podcast, and today we are going to be discussing music copyright infringement lawsuits. My name is Brian Rosenblatt, and I am a member and on the board for SERMA, and I have the distinct pleasure of welcoming two wonderful guests this afternoon. We've got law professor Dr. Haley Bosher from England, and we've got Dr. E. Michael Harrington, one of the most renowned musicologists in the country. Dr. Bosher, would you like to introduce yourself?
Sure. Thanks for having me. First of all, it's a pleasure to be here, all the way from England. Thank you. Isn't it so nice? Technology allows us to do this. So I am, a senior lecturer at Brunel University in London, and my research specializes in copyright in the music industry. I recently wrote a book called Copyright in the Music Industry, which explores all the legal regulation around music. And I also host a podcast myself called Whose Song Is It Anyway, where we also discuss more on the creativity side, but also how the laws and regulations around creativity interact with the music industry as a whole.
So, Dr. Bosher is just a little bit modest. She is the individual that law firms in the UK hire to teach their barristers, their litigators, how to litigate copyright and trademark infringement lawsuits. When they're looking at how do we defend, how do we prosecute this case, Dr. Bosher is the one who's going to help dictate those strategies and implement them. Dr. Harrington, please introduce yourself.
Hi, well, thank you again. It's a pleasure to be here. And my name is Michael Harrington. I'm a Bostonian, but I live in Nashville. I've been a professor of music theory, composition, ethnomusicology, a lot of subjects over the years. Presently, I'm working a lot at Berkeley, and I created their copyright law and the music business online class, and a few other classes for the online curriculum. I work as an expert witness in a lot of cases. I was the expert who was involved in freeing We Shall Overcome, that great work that's now in the public domain. And I work in a lot of other cases in the United States and elsewhere.
So, Dr. Harrington is also a little bit modest. He's one of the foremost musicologists in the country, who's been involved in what feels like every major music copyright case for the past several years. But at Berkeley, where I have many of my musical clients come from, he has lectured and he has taught almost every one of my clients. So thank you for teaching them how to challenge me. I always appreciate that.
Oh, that's great. I didn't know that. Thanks.
So, all right. So the purpose of today's conversation is over the past several years, there have been what feels like a preponderance of music copyright infringement lawsuits. And we'll touch on the Blurred Lines case with Pharrell and Robin Thicke and Marvin Gaye. We'll touch on the Stairway to Heaven, the Ed Sheeran, the Dua Lipa case. But most recently, there's been litigation filed against Mariah Carey. For the first time in ages, it feels like she's back in the press. And it is over the All I Want for Christmas Is You song that she released, I want to say, 25 years ago. Are you both familiar with the case, with the litigation?
Yes.
Yes.
Okay. So, who wants to start? What are some thoughts about this particular case? Or if you want, I can give a little more background.
That's all right. So,
No, go ahead, please.
I was just going to say we heard about it immediately all the way across the pond. And, I've been, as you said, involved in these kind of cases a little bit over here. And we recently had this really big Ed Sheeran case in the High Court, in England, Wales. And so as soon as the press heard that there was a similar case with Mariah Carey, which obviously we all know the song, everyone got very excited. So you're right. 27 years ago, actually, is when she first released the song on a Christmas album, and the previous song, or by the same title, had been released a few years before. So obviously, it was very curious why this case would come up now. So that was my first initial reaction. I was like, "This is weird. This is a really old song, really old, but yeah." Old for bringing in action now. So went and read the complaint, and it's a very peculiar complaint in terms of the actions being brought and the claim, because when we'll talk about obviously the bloodlines and like you said, there's a trend in this area, but the trend is usually around the song sounding similar. In the complaint, it doesn't actually specify what parts of the song that they believe are similar, or whether there's been substantial taking, or whether there's been access, or whether there's been actual copying, all of these requirements that you actually need in order for there to be copyright infringement. They've just said, we registered this copyright and you used it without our permission, which is very curious, to put it politely.
So the claim is for $20 million. The case is filed in the fine state of Louisiana. Andy Stone is a New Orleans-based musician who performs under the name Vince Vance and the Valiants. He filed the lawsuit against Mariah Carey and her co-writer and Sony Music Entertainment, alleging copyright infringement over the song "All I Want for Christmas Is You." Now, typically, and I chose this case to start with because I think Dr. Bosher just really hit the exact issue here. Is most of the time we're talking about infringement, and is one song so similar, has somebody copied? And the reason why you don't see the copying issue in the complaint, they're different songs. They're entirely different songs. The only similarity in these two songs is the title. And under the U.S. Copyright Act, you can't get copyright protection for the title of a song. So, this is kind of the outlier. This is kind of the least relevant of the cases that we're going to talk about. But what's nice is it raises the issue. It brought out, what are we really looking for? So with that, let me ask, and I know that the UK system is a little bit different than the US, but why don't you tell us briefly what is copyright?
Okay, take it back. Yeah. So copyright is a type of intellectual property right that protects creative works such as music, books, films, sound recordings, all different. In different countries, the rules are slightly different, but the principles are very much the same. And so copyright is granted to the rights holder if they have created something that's original, but that doesn't necessarily mean that it has to be unique, which is interesting when you think about these copying cases. Also, it only protects the individual expression of an idea and not an idea itself, which is also relevant in the Mariah Carey song, because a song about Christmas, and even a song about missing someone at Christmas, is most certainly an idea. And Mariah Carey's "All I Want for Christmas Is You" is an individual expression of that idea. And we don't allow copyright to protect ideas for a reason, because we want to balance all of the different interests in copyright and make sure that we encourage creativity by giving reward to the creators, but you don't stifle creativity, because if you overprotect, then obviously we'd only ever have one Christmas song and not all of the Christmas songs that we have. So that's another important factor about copyright to remember, the principles. So I don't know if you want to then, should we explain a bit more about what the test is for copyright infringement?
Absolutely, please.
So again, the specific laws and the specific tests are a little bit different in the UK and the US, and actually all over the world, but the general principle is the same. So bearing in mind that copyright only protects the original expression of ideas, copyright infringement is taking the whole or a substantial part of a copyright protected work without permission, or an exception. In America, you call it fair use. Over here, we call it fair dealing. So taking the whole of a work is pretty straightforward. I took the whole thing and I played your song and I didn't pay you a royalty for it, or I took your song and I used it as a sample, I should pay you a royalty. But the interesting question is whether someone takes a substantial part or not. And that's when we get all of these cases about whether the songs sound similar. So misconception, just because two songs sound similar doesn't mean that there's been infringement, because the principle of copyright is to prevent copying. So if you didn't copy, then it can't be infringement. And sometimes things sound the same because of lots of different reasons, like coincidence or common source of inspiration, or like the idea can be the same. So substantial part, this is how we explain it over here. It's not too different to how the principles of how the test is run in the US, but maybe you can give us more details on that. Is about whether the parts taken are the original parts that should be protected under copyright, or have you taken the unoriginal parts, such as the idea? And if you've taken the unoriginal parts, then there's not infringement. Even if you've taken a lot, it's not about how much, it's about the quality of what you take, is really the question that the courts will ask to decide if there has been infringement. So there has to be copying, which means you have to have heard the other song in the first place before you could have possibly ever copied it. And then the parts that you take have to be a substantial part, meaning you take the original parts that make it protectable in the first place. Does that make sense?
That makes complete sense. And to paraphrase just slightly, if someone files the music copyright infringement case, generally what they're claiming is you copied my song. Your version is so similar or so much the same that you're just copying. So as an evidentiary issue, when we go to court, it's really nice to ask witnesses questions. It's really nice for the attorneys to stand up there and pontificate and argue all day long. But I know I'm not qualified to say this is or this isn't the same thing. Michael, how do we tell, or how do we determine, what are we looking at to see if one song is the same as another?
Well, we are supposed to filter out, back to what Haley said, what the original aspects of it and the unoriginal aspects. Like if you read a Stephen King book and I said, well, tell me about page 85. You say, what? Why would you even think like that? What does this one little thing mean? They're going to certain moments in it that matter much more. And same in a piece of music. They could often the introduction might not be important, for example. Often the chorus would be. But you'd filter out what's the original expression and what isn't, and then was it copied? And often another thing that I get into a lot is to show that what people associate with the song, and they think, oh, Marvin Gaye was the first to sing this, or this bass line. In a Marvin Gaye case, the bass line was considered very significant. But it's not original to him. It predates him, and many other people have used that bass line. So if you had the same bass line, and Marvin Gaye estate were to sue, I would say that's foolish, because wait, it goes back earlier. So that's an important thing that I get to do, is trace the musical elements and when and where they originated from.
Okay, so let's actually jump into a couple of these cases, and let's put these elements directly into play. Which one would you like to start with? Dua Lipa, Ed Sheeran, Stairway to Heaven, Blurred Lines? Where do we want to start?
Should we go in? Let's go in chronological order, because there's a nice narrative arc there.
Reverse or going forwards?
From Blurred Lines, which is when we would say this trend of increasing number of similarity copyright infringement cases in music came after the Blurred Lines judgment, wouldn't we?
Mm-hmm.
Okay. So in the Blurred Lines case, the estate of Marvin Gaye sued Robin Thicke and Pharrell Williams for infringing Marvin Gaye's song "Got to Give It Up" with the 2013 hit "Blurred Lines." Went to trial. The court ruled that this was an infringement. Michael, why?
Well, I think first, because the jury decided that we don't have the written document, you don't have the words that the court would say. I think it was everything but music. I think the jury was impacted by the behavior of Thicke and Williams, the depositions, they were terrible figures. I think the lawyers wisely appealed to the jury's sense of right and wrong and said, the poor children of Marvin Gaye are deprived of copyright and things like this. Because this was the first case I ever saw that went this far and turned out wrong, where the following were not involved. There was no copying of melody or chords or chord progressions or rhythm or lyrics, and there was no sampling. They were similar in style, similar in instruments, and similar in tempo. And that's all. And one of the other problems is, and this is potentially a terrible issue that I've seen for decades, really, is when someone admits they were influenced by someone, then, so you like Marvin Gaye, then that means you copied from him. But all one has to do is look at the Beatles talking about their influences, for example, and Paul McCartney even saying we're the biggest plagiarists there are. We're Nick is extraordinaire. That's all we do is copy. Really meaning what they are is influenced. So the case, it was just, I was in shock at how foolish it was. And I was fortunate to get involved in an amicus brief later.
So the Blurred Lines case was really interesting because, as you noted, there was no direct copying, and when you compare sheet music, when you compare recordings, hard to justify where this concept of infringement comes from, but for possibly a new standard of it's a feel of the song, if you will, which was kind of interesting. The first time I know that I've seen that. Haley, why don't you talk a little bit about how do we put the music in front of a jury or in front of the judge so that it can be litigated?
Well, I think it's interesting what you just said about the feel, because, a minute ago when I was saying about the whole point in copyright is to protect creativity, remunerate the creators, and there's this really fine balance between what the scope of copyright should and shouldn't be. And so in a way, I think that the real problem with Blurred Lines was not how the music is presented to the jury, it's how copyright is presented to the jury, because they obviously felt that what they were hearing should be protected and therefore it was infringed. My argument would be with that case is that, okay, they sound similar, but that's not, copyright shouldn't be protecting that. And if it was very clear from the outset that like copyright doesn't protect feel, or it shouldn't protect feel based on the principles of copyright law, then it doesn't matter that those parts sound the same, because they shouldn't be protected. And also it's obviously interesting from my point of view because we don't have trial by jury in copyright infringement cases in the UK. And so I don't know, but I assume that would have an impact on the way that we litigate, because there's less perhaps performance and like you said about appealing to the jury's pulling at the heartstrings and talking about right and wrong and stuff like that. But our cases like this are decided by expert judges who do know the law. And especially in the UK, we have a specific intellectual property enterprise court. So they are very much experts in IP. And even in the High Court, you wouldn't have a case like this being decided by someone who didn't really know the law in this area. And I think that helps us. So, obviously we can loop back round to this, but recently we had this Ed Sheeran case and it was found that it was not infringement. And there were really similar arguments around, yes, those two parts of the song sound the same. They do. However, those parts that are taken should not be protected because they are general and in copyright terminology, we would call them an idea. But that's quite like lofty. What that means is something that's like general and common in, and that depends on the context. You know, if we're talking about a book, what's general and common in a book might be the genre, and what's general and common in the song might be the theme or the feel. Do you see what I mean? So I think it's interesting that the performance element and the delivery and the litigation in the case played such a big role, and also the jury played, I think, like you said, I think that determined the outcome a lot.
So ultimately, the jury has to determine, are these songs the same and was there copying? And in comparing the songs, the question is, what are they comparing? And if we're talking about the Dua Lipa litigation or the Mariah Carey litigation or even Ed Sheeran today, when artists and record labels and publishers are registering the copyright for the underlying compositions, oftentimes they will go ahead and send in the actual recording, and they'll do so digitally. But what do we do going with a song back from the early 1970s? We have to look at what is registered, and that's exactly what Haley is talking about, is what did you originally claim that you had a copyright in? So when we go back, Marvin Gaye didn't register this electronically. There was no internet back then. There was no email. You're not going to take a vinyl or a wax record and put it in the mail, because as soon as you drop it in the post box, it shatters. So back in their 70s, the way that artists would register their compositions is they would physically mail in copies of the sheet music and of the lyrics. But that doesn't have the feel to it, which is why we often bring in a Dr. Harrington to go ahead and address what is this. And ultimately, when we litigate these cases, we will have the musicologists and the experts debate back and forth and opine whether this is the same or it's not the same, what elements are similar, what's different, whether something should or should not have protection because it is or isn't original or has artistic value to it. But we also, at a certain point, often have to actually perform or let a jury listen to the compositions. And oftentimes you will bring in an independent musician to perform exactly the sheet music. As a kind of a side note to the Blurred Lines case, my understanding is that Robin Thicke insisted on he be the one that performed the music, the compositions in front of the jury. And unfortunately, I think the jury found that, wow, that really just feels the same. And I think that's kind of where that went.
Another problem.
Michael, is that fair?
I think so. I don't know enough about some of the proceedings. I'm friends with Howard King, and I was on a panel with him, and we talked about this. There were so many things that went wrong. That could be some of them. I'm amazed. I used the depositions to show students, hey, this is what you do not do. And lawyers need to know, like, oh, you want to prep an expert? Here's what has to happen. You know, the person, the celebrity, like Robin Thicke or Pharrell, even. Pharrell's such a nice guy, and he came off such as a kind of an offensive guy. And his character changed, and he got very defensive because he was asked things he thought he knew and he didn't. He wanted to fake it like, I mean, he needed to understand that here's a celebrity, very accomplished musician who doesn't know some of the musical terms coming his way. He should have just admitted it instead of trying to come up with funny things and contradicting himself and getting tongue-tied and all. He just blew it that way, I think.
I think you're right. So, what do we turn to next? Stairway to Heaven or Ed Sheeran?
So there's poor Ed Sheeran. There's so many cases we could be talking about when we say Ed Sheeran. So that's the first thing to say.
Well, I was going to ask.
There's talk not about one Ed Sheeran case.
Let's talk briefly, because I think you alluded to it a little while ago, but the Shape of You case. What was
Yeah. So the Shape of You case just had in the UK. So there was obviously Ed Sheeran, Shape of You. We've all probably know this song. And there's a part in the song. I'm not gonna sing it to you, but the lyrics are "Oh I, I'm in love with the Shape of You." And there's another song called "Oh Why" by Sam Chokri, and some of the lyrics are "Oh why, oh why, oh why." And he claimed that Ed had copied that little part of his song. And it was the first big case we've had in the UK of that kind for a while, and since Blurred Lines as well. There was one other rudimental, but that one didn't just hit the press as well as the Ed Sheeran one was like a really big deal. And it was a really long trial, and there was 3 years, millions of pounds later, the judge decided two things. One, Ed Sheeran's never heard of you, soz. So they couldn't show that he'd ever heard the song in the first place. If you haven't heard it, like you said, can't have copied it. And even if he had heard it, the parts of the songs that were same, that little snippets, goes back to exactly what you were saying, Michael, which is they, brought up lots of other previous music that had that same kind of scale and similar sounding kind of bridge in the song. And so they were like, well, and they also said it was so simple and so common that Ed didn't need to copy it from you. It's just something he definitely would have known as a musician. It's such a basic part of the song. And so he did eventually win this claim, but I'm making it sound like it was a really clear-cut answer, and in the end, I think it was the correct judgment. However, the fact that it took 3 years and such a long 2-week trial, it wasn't that straightforward. Otherwise, it just would have settled years ago. So there obviously was a claim to be heard, but I think that it was decided correctly.
I was going to say about Ed Sheeran. Oh, which one? Because I was involved in Thinking About You, where the gay people sued him again, suing.
Ah.
So that's the one I know very well. I did hear those songs and thought, this is really foolish too.
Is that the Townsend one where it's not actually the Marvin Gaye?
Right, right.
Yeah. And this is the one I was talking with you about, Brian, that we were saying that what Brian was saying a minute ago about where the scope of the copyright is the registered copyright. So Marvin Gaye had registered again like the score and the lyrics, which obviously doesn't include things like the percussion and the feel and the sound
Right.
of the song. It's just those written elements. And so Ed Sheeran's team were rightly arguing, I think, that the scope of the registered copyright is only what's on this piece of paper. And therefore, we should not be able to play the song to the jury because they will hear all of the other elements which are not in your registered copyright, and therefore you don't own them. They're not protected under the law at that time. And that coincided with around the same time that they were trying the Led Zeppelin case. So that's as far as I know about that one.
So in the U.S. system, copyright, and under the U.S. Act, copyright attaches when you take a new or novel artistic expression and fix it in a tangible medium. So you write a song, you record it, it's now fixed in a tangible medium. But it's got to be new, novel, and it's got to have that artistic element. And I think that the Shape of You case, I think it would have turned out the same way in the United States, in the federal courts here. And I think Michael will agree that I don't know that there is anything so artistic about, and I'm just reading this off the screen, O-I, O-I, O-I versus O-Y. And like Haley, I will do everybody the favor of not singing the lyric.
Because there is the same kind of like rhythmic clicking, although one song is much slower than the other one. But yeah, I would agree that those are unoriginal elements. And it goes back to what Michael was saying earlier, is that it's a normal part of the creative process to take inspiration. And ultimately, in music, you are limited in your choices because you're usually operating within a framework. First of all, you only have 12 notes, and you're usually working within the framework of a genre. So then you're going to have a particular shape to your song anyway. And so, of course, there's going to be coincidences and there's going to be similarities between songs. And I think that's why we really always have to come back to that kind of point, which is just because two songs sound the same does not mean that there's been infringement. And in the Ed Sheeran case, what they fell down on the first hurdle, which is there was no access. So we can't have possibly copied it because we never heard it before.
So that leads to a great question for Michael then. As a musicologist, as the expert, how do you argue, how do you tell the jury that there's nothing protectable here, there's nothing so artistic, or there's something that is so blatantly common that it's not, that protection isn't warranted? How do you make that argument?
I think you show them a few basics. You don't. I remember the first case I was ever in. I was for the plaintiff, and they wanted to give me 3 days to teach the jury music theory. I thought, oh no, make sure they really don't like me or music theory, right? I think you could do it just in a few minutes and show some basics. For example, if it's OI, which I was not in this one. The other Ed Sheeran is 4 notes in the bass, 1, 3, 4, 5, repeated. And I would show them, for example, oh, this occurs in these other songs, and I'll have 50 of them ready or more, and I'll put them in the same, I'll arrange them by key and show that, oh, other people did it as well. And going back to Louis Armstrong, oh, when the saints go marching in, oh, when the saints, those notes, that's 4 notes repeated 3 times, make that the bass line, and that's your song. So Marvin Gaye did it, Ed Sheeran did it, Louis Armstrong did it, the Beatles have done it, all kinds of people did it. So I think it's just to show them, oh yeah, these are similar, but they're not original, and that's the standard. It has to be something that's has a modicum of creativity, and especially if it's something. If you ever think of, again, I can go back to Beatles, "Goo Goo Gajoob" from "I Am the Walrus." Or the theme song of the Flintstones meet the Flintstones. These are words you don't find in an old Irish folk song or something. So I think it would be to show a lot of prior examples and say this is common material. Other people have arrived at the same conclusion, not because of music theory or anything, just because of what surrounds them and what seems to feel good. Sometimes when you play a piano or you play a guitar, a G chord is a nice sounding chord. In E flat, a beginner will never go near an E flat chord on a guitar because of the tuning. So things that are likely to happen more often. I think it's important to show a jury that. That's how I go about it anyway.
Okay, so would that include things such as descending musical patterns or different scales?
Exactly, and that's the Led Zeppelin one. This is a good segue, I'm guessing, to Led Zeppelin. Yeah, I was approached about that really early, before anything had happened, um, and I just laughed. I said, "Well, I really think that is completely silly, because it's the notes. If you were cleaning a piano, you clean this key, you clean the next key, you clean the next key. It's all you're doing is playing adjacent notes, the closest possible. And that bass line is from the 1600s, and the chords with it are from the 1600s. It's just 5 notes, and it was preposterous that there'd be a lawsuit over that, because there are so many examples last week and last month and 400 years ago and 200 years ago. So yeah, that was my take on that, my
So,
quick version.
so the entire Led Zeppelin case was it was like a law school exam, issue after issue after issue. The first one that popped up was Jimmy Page and Robert Plant were sued for copyright infringement nearly 50 years after the song was first released, which blows every statute of limitation known to mankind. but they were sued on the re-release by their record label,
Right. Mm-hmm.
not on the original release. For those that don't know, they were accused of ripping off the opening riff from a song called Taurus by a band called Spirit. And, the court got into, did they ever have access? Did they ever hear the song in the first place? The courts got into the production, let alone not just the underlying composition, but the production. And if I'm correct, I think that the court said we're not going to allow the music to be played for the jury, exactly as Haley was saying before, because you've got all these additional production elements that are involved, and that's not what was claimed on the original copyright application and what was originally submitted. And I know that it came down to a comparison of the descending musical patterns, and one of the examples that was used was from 1964, the Disney musical Mary Poppins, the song Chim Chim Cheree, which had a very similar type of feel to it. So I don't know if the House of Mouse is now going to claim it owns part of Led Zeppelin's catalog, but we'll see. So Dua Lipa is now involved in two separate lawsuits. I think, if I'm correct, I think they're both over the song "Levitating."
Yes. Mm-hmm.
And are you familiar with these?
Yep. Uh,
So,
Well, I think, isn't it interesting, just before you explain that, I was just going to say, like, with the Led Zeppelin case, I thought that we would turn a corner after that, because the decision to rehear the case, and they decided again that it was an infringement, had a bearing on the other two cases that we've just mentioned, the Ed Sheeran case, because they then said about the scope of the copyright being limited to the registered copyright. And also the other case that was going on at that time, which was the Katy Perry case, because that was all around an 8-note ostinato, the scale. And so she'd lost the case. Then we had the Led Zeppelin finding. And so then literally like the next week, she appealed and won the appeal when they referred heavily to the Led Zeppelin case. So I really thought at that point, oh, we're turning a corner here, and people will, stop filing copyright infringement complaints for similar songs, because the courts have been very clear about these tests that we've been talking about, and not to be too over ambitious and too excited. And especially with the Blurred Lines case, we said there's a floodgates. Lots of people filed after that, because it was a successful infringement. And then we saw the Led Zeppelin, it was not infringement, which also had a bearing on the Ed Sheeran case and the Katy Perry case as not infringement. But then you're right. Then we're still seeing these filings, and people like Dua Lipa and many others, of even the Mariah Carey one that we mentioned, are still being sued for copyright infringement. So it is still happening. I was surprised.
yeah, it's interesting, and none of these cases are necessarily precedent, but I think what we're seeing more and more is that the legal community, the attorneys, the musicologists, the experts, and the judiciary in all the different federal circuits now are being educated by these. So even though some of these cases are not necessarily precedent, they are seeing the common trends. They are seeing how the decisions are being rationalized. They are seeing how the appellate courts are supporting or overturning various decisions and calling out maybe what should be considered folly in terms of legal reasoning. But just one example of why these cases are still being filed. Going back to Stairway to Heaven, Taurus sued for copyright infringement based on the re-release of the song Stairway to Heaven. And during the 5-year period that was at issue during the trial, because you couldn't go backwards beyond that, but during that 5-year period, the song, which at that point was 45 years old, still generated 3.4 million US or 2.6 million pounds. So I think that potentially answers the question why.
So
Yeah.
there's your motivation.
That's why
Exactly.
people want to sue Led
Exactly.
Zeppelin, Pink Floyd, and the legacy bands forever. The music still sells.
Absolutely. Absolutely. Do we want to talk about Dua Lipa?
Which one? Well, do the most common one.
Uh,
The first, the
Levitating.
first of the two. There were two. I was involved in the chronologically. I was contacted earlier, but it's the second one. So do the first one. I think more people will know that one. I'm familiar with that as well.
Well, I think the first one was it was over the song "Levitating," and it was filed by the Florida reggae group Article Sound System, claiming that she had lifted lyrics um, from their 2017 track "Live Your Life," and they argued that there was copying, that there was similarity. They didn't necessarily point out exactly what the similarity was, but then they indicated that it was highly unlikely, and I'm just reading this off my screen, highly unlikely that Levitating was created independently, so they're alleging the access and the direct copying. Um,
Go ahead, Haley.
so that was the first one.
Oh,
Michael, tell us about what you were
okay.
doing
Well, this one
involved in this
I
case.
was not immediately involved in.
If you're
Oh,
allowed to.
yeah, yeah. This
Yeah.
I've been contacted about the. Um, it's funny. It becomes like almost these days. It's like forensic outsourced musicology, because all these people post on YouTube their defenses, and a few of them can be good. But it came down to in that particular. I'm in Levitating two. Let's call that one Levitating one. It was da 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 da, that rhythm, which is like the Charleston rhythm from the 1920s. It's also the beginning of a clave rhythm, which permeates thousands of pieces of music. Its origin from West Africa, all through the Caribbean, New Orleans, rock and roll, da 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 da. And they both shared that rhythm with, I think, the same or similar chords in one section. So that was the part that had even audiences in internet land saying, oh, they copied it. And it had people like me saying, oh, no, no, it's these other things. And I could point to many earlier examples. It's not an original rhythm. It's just a little dot, dot, dot. It's like paying attention to the drummer for a change. And that's all that's really in common. That's my quick take. So go ahead, Haley.
So on my playlist of all the songs that have been in dispute, when you listen to the songs, you're like, yeah, you're right, they do sound the same. But again, the parts that are same are unoriginal. So that's the question that we have to keep coming back to, and it's a bit like what you were saying, Brian, that like it's looking at, there's more cases, and although they might not be precedent, they are of course like raising the kind of understanding of these principles, which is again, well, when we see the Mariah Carey case, for instance, we're like, what were they thinking? Because have we not got this now? Like we're learning from these cases that we don't protect these common elements that have been used before, and like I said, we don't protect titles, and still the claims are being brought. So it's very interesting that people still think that they do have a shot at convincing a judge or a jury that I also think, having spoken to people who are the claimant or the plaintiff, they genuinely are so convinced.
Right.
It's not that they're always like just trying their luck. I genuinely know that they genuinely believe that. And I think maybe that comes from the nature of creativity a little bit, where it's like, I've made this thing and it could only have sounded exactly like that because it came from my personality and my skill and, how I perceive the world and all this kind of stuff. And someone's made something that sounds exactly the same. This could not have happened any other way apart from copying. So it's very emotive copyright, because I think people are very connected to their creativity. And I think that can blindside them when it comes to trying to maybe give legal advice about the test in a very objective way, where when you're saying things about like how common this element is, maybe they just don't want to hear it because the way that they see it is like, this is this beautiful, unique thing that I have made and you've copied it. So I think sometimes it can be hard to give advice around that without when it's so emotive. I did hear somebody say the reason they think it took 27 years for the Mariah Carey case is because that's how long it took
I
them
was
to
hoping
find
you
a
were going to
lawyer
go
who
there
would
with that.
who would bring it.
I know.
Well, if you look hard enough, you'll find, right?
Yep.
Because it's so
Yeah,
bad.
no, I think you're spot on. I
Oh,
think
funny.
that you know, music, art, creativity. I think it's very, very personal, and I think it's wonderful that society is willing to give a limited time monopoly to protect and encourage individuals to create. I think that's a benefit for the public good. And when somebody creates something and they're told, "Oh, it's not so original, it's not so creative," I think that does often come across as a slap in the face, and I do think that people can be offended by that, whether accurate or not.
I know.
Um, so
I think
it,
that's a really
it,
important point, Brian. You're going off of Haley's remarks about how personal it is, and that's why a couple things. One, I like to deal with the attorneys because they're not emotional; they're rational beings, and the songwriters will not be. And also, when it comes to discovery, anything I say to the songwriter, like, "Oh no, that can be." You could have that. But like I've had examples where, back to the personal, a woman contacted me years ago when the Dixie Chicks had a song out called "Ready to Run," and it's a song about being ready to get married, and then they run when they're at the altar. They take off, and she had written a song about that, and she'd because it was her experience to get cold feet. And I was trying to explain to her, I said, your songs have nothing in common. And you both have had experiences with marriage and not being ready for it, and you split. You run crazy from it. I said, but your songs aren't similar, and copyright doesn't protect that. And she was just angry and stayed angry. And I said, let me talk to your attorney again, because that's early on. I just didn't understand, like, this is why I need to deal with attorneys and not songwriters, because of things like that.
well, I want to thank both Dr. Bosher and Dr. Harrington for joining us today. Um, music copyright litigation is, for me, one of the most exciting areas of law. And we always fight for our clients. We want to protect their rights. We want to enforce their rights. But when we get into music copyright infringement and this type of litigation, we've got the strategery for the rules of civil procedure. We've got strategery over evidentiary issues. We've got technicalities over what is or isn't claimed in the underlying copyright and copyright application. And then when we get past all of that, we then turn to the truly artistic component. And are there or are there not similarities here? Are these similarities so deeply rooted in society that there is no originality to it? Or is that just an absolute copy? And getting to work on these cases and getting to work with experts like Dr. Bosher and Dr. Harrington just makes my job exciting and a thrill. So I want to thank you both again. Thank you very much. And stay tuned for the next
Thank you. It was great.
SERMAPod.
Thanks for having
My
us.
pleasure.
Okay,
Thank you
great.
very much.